Hi, and welcome to the Taking Care of Tutu podcast. I'm your host, Meg Obenauf, and today we're going to do a solo episode with our team asking a bunch of our frequently asked questions. So we're probably going to call it legal tips for Tutu or something of that nature. Before we get started, if you are interested in more content like this, like legal estate planning, legal elder law type of content, or caregiving support in Maui, please like, follow, or subscribe to this podcast because that's super helpful for us. Thank you. Okay, I'm going to play their questions and then I'll answer them one at a time.
I thought this week their beneficiary trust. The trustee hasn't given them keep the trust or any idea what's the is the trustee supposed to have an accounting or the touching is the beneficiary?
We get this question a lot, and the answer is yes. So when we're representing or assisting a trustee, we tell them try to be as transparent as possible. Now, of course, if you're this beneficiary and you're asking at the funeral of the person who passed away, that's gross. Don't do that. But if a reasonable amount of time has passed and you haven't heard anything, the trustee does have a job to reach out to the beneficiaries to give them a copy of a trust. And they do also need to provide an accounting. And accounting is just, here's what there was when I took over as trustee. Here's all the bills I paid. Here's what's left. And you have a right to that, especially if you're, for example, a 20% beneficiary. You need to know 20% of what. And so the trustee does have an obligation to figure out what the assets are, pay the bills, notify the beneficiaries that they're a beneficiary, give them a copy of the trust, or at least of the relevant part of the trust, and keep in touch with them. So we always suggest to our trustees that they be transparent and try to push out information. I like email to do that because then you can, have a copy of it if it's in writing. It's kind of more business-like than texting, but you don't have to send paper letters. Hi, I'm the trustee. I'm going to go meet with the lawyer to get officially appointed as the trustee, and then I'm going to start getting all the bills paid for your mother, for example. If you have any questions, let me know. And then sending out a copy of the trust and then going through the steps and making sure that the beneficiary gets awarded what they were supposed to be awarded. We've had calls where people say this exact question. I'm the beneficiary of a trust. I was still paying the mortgage for the property I was awarded because I was living in it, but then I got a foreclosure notice. And we said, how long ago since the person died? And they said 10 years. So 10 years is too long. You should definitely have your accounting before that time. That's usually a trustee who's just not doing an accounting if it's been 10 years. 10 days is too short. But after a reasonable amount of time, if the person has time to figure out what the bills are and kind of get their bearings, meet with an attorney or the accountant or both, then I think you can start expecting that they should be reaching out to you and that you should have a copy of the trust so you understand if you are included or not.
My child wants to go and taking out a mortgage on their home. They want to be 50-50 on title.
I really don't like this at all. So what we have seen is it's really common. Obviously, real estate here on Maui is super expensive. So if the parents have a piece of property and they live in the main house and they have the ability to build an ohana, sometimes the child will want to build the ohana and live on the property. However, the child doesn't have enough money to build that ohana. The perfect scenario would be the child can just pay to build the ohana and then we can adjust the estate plan accordingly. But a lot of times the child doesn't have a spare $200,000 or $300,000. And so they want to take out a home equity line on the parent's home, and the bank is telling them they need to be on title. This is where we get really nervous because we've just heard lots of stories from clients where the property ends up getting lost, and we want to protect our clients. We want to protect the property that they worked so hard to get during their lifetime. And so if they really want this, not that the child is putting them under duress, but if the parents really want this, they want their child, say, to return back from the mainland and they want this to happen, they want to be close to their grandchildren, then and they want to take out a home equity line for that. Of course, we have to explain that they are responsible for that if their child stops paying. But also, the child does not have to be 50% on the deed. So when they do the paperwork for the home equity line, oftentimes the child will get put on the title to the house. But usually our advice is just have the bank put the child on for the smallest amount possible. If that's 1% and that will work, great. If it's 4%, 10%, whatever is the smallest percentage that the bank will be okay with. Because what we see a lot is people don't know. And so it's 50%. And so they've just given away half of their property.
Are the benefits of TE? They protect finances.
Okay, so TE in Hawaii means tenants by the entirety. It's a way to hold real estate. So when someone comes in and they say, oh, we're a married couple, we own real estate, we will pull the deed and we'll look at how they hold the real estate. So they might hold it tenants in common, they might hold it joint tenants. Married couples and registered reciprocal beneficiaries are allowed to hold real estate tenants by the entirety. And it does two things. One, it says if one spouse dies, it automatically goes to the other. Joint tenants does that too. But the thing that tenants by the entirety has that no other way of holding ownership has is that it also protects a spouse from the creditors of their spouse. So let's say one of the spouses is a contractor, let's say it's the husband and he's getting sued. The wife owns the property in the entirety, so they cannot try to get to the house. Let's say wife causes an accident or she gets sued for something in her job. Same, the husband cannot. And so if she's being sued, they don't have to worry about the home losing their house. So we've had clients who get involved in lawsuits, and this is really important form of asset protection. It's also really nice because we used to not be able to put real estate in a trust and keep the tenants by the entirety. So sometimes people would still leave their house outside their trust if they were like a physician or someone who had a lot of liability. But for like maybe the last 13 years, we've been able to put a property into a trust and keep the tenants by the entirety creditor protection as long as we put certain language in the deed. So again, it doesn't protect you if you and your spouse don't pay your mortgage or you and your spouse don't pay your joint credit card. But if one of you is being sued and not the other, it will protect the real estate. So not every state has that, but that is something that we have here in Hawaii.
We have someone that moved here to Hawaii and started community properties. Does that affect anything? I know Hawaii is not community properties.
Okay, great. This is a little bit of a complicated one, and it's kind of niche. It only applies to people who move here from a state like Washington or California, where they have community property. So there's about 9 community property states in the United States, and Hawaii is not one of them. But we do have a law that says Hawaii will recognize community property that's brought here from another state. So, for example, if you sell a house in California and then take that money and you buy a house in Hawaii because you're moving to Hawaii, and then you move to Hawaii after that, you can have on the deed that you intend to keep that as community property, and Hawaii will honor that. And so, why does that matter? The way we do it is we will on the deed, like we will mention that the intention is to have it count as community property. On a trust, we will schedule it as community property. There's a Schedule C community property, and we'll list the house as community property as opposed to joint property, which is a different thing. And so we are trying to um, protect that community property status that they had when they sold the California property. So, why does that matter? In our world, which is estate planning, it only matters if one spouse passes away and the other spouse wants to sell that piece of property. And so that does happen sometimes because, maybe they want to get a different start, or maybe the house was just too big and they're getting older. They're going to sell it and they're going to get something smaller.